My name is Associate Professor Ronli Sifris. I'm the Deputy Director of the Castan Centre for Human Rights Law. And on behalf of this panel, I would like to acknowledge the Wurundjeri people of the Kulin Nations on whose land we are gathered today, and to pay my respect to elders past and present. I'd also like to acknowledge our support for a treaty with First Nations people here in Victoria, particularly following Ruben's enlightening presentation this morning. Our second panel discussion focuses on perspectives on the law, human rights and the migrant experience, and I'm really delighted to be bringing together three leading scholars in this area. Our first panellist this afternoon is Professor Justine Nolan. Justine will be presenting on the approach of Australian companies to addressing modern slavery and what needs to change. Professor Justine Nolan is the Director of the Australian Human Rights Institute and a Professor in the Faculty of Law and Justice at UNSW Sydney. She has published widely on business and human rights and modern slavery. She advises companies, NGOs and governments on these issues and is a member of the Australian Government's Modern Slavery Expert Advisory Group. Prior to joining UNSW, Justine practiced first as a corporate lawyer and then as an international human rights lawyer in Australia and the US. Please welcome Professor Justine Nolan.
Thank you so much, Ronli, and thank you so much to the Castan Centre for the invitation. It is always lovely to visit Melbourne in winter. It really makes me remind me when I go back to Sydney to stop the fuck complaining. But it is lovely. It's always lovely to be in Melbourne. Maybe just not July. So it's great to be at the Castan Centre and having this back in person and being able to connect with everybody. I mean, it was, such a great effort that we kept all of our conversations going online for so many years, but it is nice to chat with people over a coffee and get to see people's faces again. So as Ronli said, I'm giving a sort of a short highlights tour of the modern slavery issues in Australia, and in particular trying to focus on where we go from here. So some of you will be familiar with this and some of you won't be familiar with this topic, so I'm just going to give you a sort of a short overview of where we're at, why we're talking about this issue, and then focus on how we might move forward in relation to it. Because modern slavery has got a lot of attention in Australia in the last couple of years. In the last decade, really, there's numbers that have started to be attached to sort of the people who we would classify as being victims of modern slavery around the world. Particularly, that effort has been led by the Walk Free Foundation and the ILO more recently. And their most recent estimate says there's around 50 million people around the world in modern slavery. And they also estimate there's about 41,000 people in Australia labouring or living in these conditions. Now, these are very different numbers from the numbers that the Australian Federal Police releases, usually annually. And they said for 2022, 2023, they had 340 reports of modern slavery in Australia and 43 reports of forced labour, which is usually associated with corporates and company supply chains. So our numbers are somewhere between 340 and 41,000. Now, the 340 is a very misleading number because what we know about this crime is that there's really low reporting rates. So there's a large number of victims, but reporting and remedy is one of the really complex areas and something that I'll come to later. So the 340 reports that the AFP received could not at all be accurate of the current situation. So what sorts of things are we talking about, particularly in Australia? Modern slavery is a very broad term that the United Kingdom introduced when they introduced their Act in 2015, and then Australia adopted it as well when we introduced a law in 2018. And it encompasses a number of practices like debt bondage, forced labour, child labour, forced marriage, and slavery itself. And it's sort of a modern term that an umbrella term that brings together all these different types of crime. Obviously, there's been international laws and prohibitions against slavery, for over nearly 100 years now at the UN level. But what we've started to see in the last decade is it being associated and, associated with companies and corporations, not just it's a government problem. We're also looking at, well, how is this occurring in corporate supply chains? So in Australia, in 2018, the government passed a Modern Slavery Act. And the idea was this was addressing modern slavery in corporate operations and supply chains of Australian companies. And what it basically requires is Australian companies who have more than $100 million in annual consolidated revenue a year to undergo these reporting obligations. The government set up a modern slavery register, which you can Google online, and you can see that there's now nearly 10,000 statements being filed by companies, and it's covering about 15,000 entities in Australia, including the Commonwealth Government. So this has been going since 2018. We've had all of this lovely reporting, and so I'm sure you're thinking, surely we must have solved the problem by now. Surprising, we haven't. So one of the big questions when you think about this area is the different types of regulatory approaches you take to addressing these really sort of endemic and difficult problems to address. So Australia used this technique of disclosure, saying that the way that we're going to regulate companies is that we're going to ask them to basically self-report. So what are the risks that are going to happen? Identify where modern slavery is happening. It might be in your cleaning supply chain in Swanston Street. It might be in your tomato picking out in rural Victoria, or it might be overseas in the manufacture of electronics that then come into Australia. So it's both in the operations of a company and it's also in the broader supply chain. So given the problem didn't seem to be sort of fixing itself quite as easily as perhaps the government was hoping for, I was part of a research project with 4 other universities, including RMIT here in Melbourne, and the University of Melbourne, the Business School, and 4 NGOs, including the Human Rights Law Centre here, where we decided to examine the reporting statements of 100 companies in 4 high-risk areas in Australian reporting. So we looked at companies who were sourcing garments from China, who were getting rubber gloves from Malaysia, horticulture in Australia, and producing seafood from Thailand. So we knew, based on all of these reports around the world, that these were high-risk areas of modern slavery and that modern slavery was happening in these supply chains. So we analysed these statements over a period of 2 years, and we found sort of 3 main things. That within the Modern Slavery Act, there's mandatory criteria that companies have to address, and that 77% of the companies that we looked at didn't even address all of the mandatory criteria. Secondly, we knew that all of these companies were operating in high-risk modern slavery areas, but more than half of them failed to identify that there was a risk of modern slavery in their supply chain. So, for example, 3 in 4 garment companies sourcing from China failed to mention risks of Uyghur forced labour in the cotton sector with it. Just under 1 in 2 food companies sourcing horticultural produce from Australia identified it as high-risk area. So we knew that they couldn't even get to the stage of sort of self-identifying. And then finally, the third point we found was that companies were failing to demonstrate any effective action. So that those that were reporting were not reporting that well, but then very few were actually taking action to address it. So Australia's sort of policy lever, if you like, was to set up a system where disclosure was going to be our saviour. But it wasn't actually requiring companies to do anything. It was just doing reporting. So it was a system of process, not focused on outcome. So then in 2023, so our research over 2 years highlighted these issues, and then in 2023 the government had commissioned an independent review of the Act, which was very thorough, and Professor McMillan headed that, and he said in that report that he noted that there's no hard evidence that the Modern Slavery Act in its early years has yet caused meaningful change for people living in conditions of modern slavery. So what has it done? Well, it has done an amazing job of raising this issue and awareness around companies. So many companies in Australia didn't think that human rights were relevant really to them. And many of them still don't, but they think that modern slavery is not always human rights. And so they started to socialise the idea, started to have these discussions at board level, the better companies were filtering it down and really taking responsibility and taking a really proactive approach. But many of them were sort of just doing it more as a tick box exercise. And so what it showed to us that perhaps that this disclosure regulatory approach is not as effective as people might thought it would be. Which was no surprise, of course, to all the academics who've been saying this for many years. So, there's sort of three main critiques of these types of disclosure laws. One is that the reporting tends to be vague, inconsistent, often not verifiable, so we're not actually getting that much new information in relation to it. There's an enforcement vacuum, so the Australian law doesn't have any enforcement in relation to it. It's really relying on the market and civil society to police the statements and figure out where companies are going wrong and where the self-reporting is inaccurate. And thirdly, the process it's all focused on process, not outcome. So there's no action in relation to it. So what needs to change, I guess, where we are, and the Macmillan report is a really good starting point if you're interested in this area to have a look at. I think there's two main things that I would say that we need to focus on in Australia. First of all, and this is relevant to areas much broader than modern slavery, that if we're going to design new laws, and we're going to try and have a policy mechanism to address issues, whether it's child rights or whether it's modern slavery, let's actually think about how we design laws that are effective, not just that look good. Let's take the time to design these laws. So if you're going to design a law that relies on disclosure and then you're not going to have any enforcement framework attached, it's no surprise when companies may not actually report under it. Sort of the analogy I use is that if the government decided to embark on new tax reforms and they said to business, we actually don't think we need an enforcement framework in relation to this. It would be great if you file a tax return, but if you don't, so be it. Someone will point it out and we'll address it then. Everybody would be like, what? That doesn't seem to be that effective. Yet when it's something as fundamental as a crime against slavery, we're happy to follow that soft approach and sort of say, nice if you do, if you don't, we'll keep working on it. So the law as it was conceived wasn't logically going to be effective. And we've also seen the way that laws in this area are moving much faster in Europe. They're incorporating action, not just process. So they're requiring companies to deal with something called due diligence, human rights due diligence. So to undertake actions and then report on it, all part of the same process. So our law needs to be strengthened to do that, and I would argue go even further to say that companies should actually have a duty imposed on them to prevent modern slavery. And so we have to think about how we design laws more effectively in relation to it, and that are co-designed. People who've been impacted by these laws, people who have on-the-ground experience are part of that drafting process rather than the top-down approach, which was largely, not fully, but largely drove the first iteration of this law. And then the second aspect, that's the sort of the government policy aspect, the second aspect relates to business themselves. So we're beyond the stage now where we sort of deal with human rights and we think about the state responsibilities. Human rights is very much these days impacting and impacted by global powers, which are corporate. Many of the large global companies have much more power than many states at the moment on the international stage. So we have to recognise that we need corporate buy-in to make changes. We can't just draft a law where companies are not going to be involved within it. But companies also have to lead in this in accepting that the way they're operating now needs to be transformed. And part of that in particular is their approach to how they develop business models in supply chains, which is very much a sort of a top-down squeezing focus. And by the time you get to the lower tiers, where modern slavery is more likely to be found, both the factories or the mines or the fields, those employers and then the workers themselves are absolutely squeezed because the terms are dictated by the top. There's a rigid sort of dynamic of global supply chains which affects purchasing practice throughout it and very much power imbalances. And there are some really interesting companies around the world that are basically taking a different approach. And a new project that I've embarked on is looking at this exact question around where companies are taking what we're calling a transformational approach. How are they doing it? Why are they doing it? Partly it's driven by law, but not always. But what fundamental changes are they making that will change the way and will reverberate through their supply chain? So one that we have been looking at is a French sneaker company, Veja, which produces in Brazil. And last year we went to the Amazon to look at how they're sourcing rubber in a sustainable way, both to protect the workers and empower the workers that are sourcing this rubber, but also address deforestation in the Amazon. I won't go in it today, but if you're interested, there's a sort of a short paper on the Australian Human Rights Institute website which summarises this sort of new business model that we're starting to look at in relation to them. So I think I will leave it there, Ronli, and sort of just give you a taster of some of the issues that are there. Thanks.
Thank you so much, Justine, for a really interesting and stimulating presentation. Thinking about the connection between modern slavery and corporations, thinking about the approach of corporations, as well as that critique of the Australian government's approach. You really packed a lot into that presentation, so thank you for that. Our next panellist is Associate Professor Samantha Currie. Samantha will present her research examining the role of UK immigration legal aid lawyers who represent people with lived experience of human trafficking. The research exposes the difficulties faced by the lawyers seeking to protect the human rights of their clients. In particular, it focuses on the combined effects of the perilous state of the legal aid system, changes in immigration law and policy, and use of anti-lawyer rhetoric by politicians. Samantha Currie is an Associate Professor in the Faculty of Law at Monash University and an academic member of the Castan Centre for Human Rights Law. She joined the faculty in August 2023 from the University of Liverpool in the UK. Samantha is a socio-legal scholar with expertise in migration, modern slavery and access to justice, and with a track record of producing high-quality, empirically informed research. Her current research focuses on the engagement of trafficking and modern slavery survivors with law and policy processes, with a particular focus on the nexus between migration and modern slavery. Please join me in welcoming Associate Professor Samantha Currie.
Thank you, Ronli. I feel quite embarrassed by that long introduction, but thank you. It's really wonderful to be here. It's my first Castan Centre conference, and it's been so inspiring to hear all of the speakers so far today, and slightly intimidating as well. Because they've all been so impactful and powerful. So as Ronli just mentioned, one of my research areas is sort of the status and experiences of people who've been trafficked, so experienced a type of exploitation falling under that modern slavery umbrella that Justine has just spoken about. And the cohort that I focus on have been trafficked, and they also have an insecure immigration status. And I apologise because the research I'm drawing on today is focused on the UK context. So I'll explain a little bit about that, and then hopefully towards the end, and then maybe in questions, we can think a bit more broadly about the implications for Australia and in other contexts too. So in my recent work, what I've been doing is focusing on legal practitioners who represent this cohort in the UK, so people who have lived experience of trafficking but have no security of immigration status, and so are at the mercy of immigration enforcement, often immigration detention, and certainly have difficulties in accessing rights because of that insecure immigration status. So the lawyers I've been engaging with have been seeking to assert and protect the human rights in particular of their cohort of clients. So what I thought I would do today, with it just being a short presentation, is to just talk briefly about the nature of the casework that the lawyers do when representing these clients, to give some context, and to offer some reflections about what the research and the findings indicate in respect of recent UK governments, and there's been many iterations over the last few years, how they've treated this vulnerable cohort of people. And if there's time, but there may well not be, just offer some reflections on the nature of lawyering and of practicing law within that anti-trafficking and migration space. Okay, so in terms of the casework that the lawyers do, the legal work that the lawyers do very much sat at the sort of intersection of what we might deem the legal framework on modern slavery on the one hand, and then law and policy on immigration and asylum on the other hand. So in terms of methodology, what the research involved was around 50 interviews with solicitors, barristers, and then some support workers, observation of legal practitioner training events around trafficking and immigration, observation of proceedings in the immigration tribunal in the UK, and then some case file analysis of trafficking case files, looking in particular at the sort of discourse between lawyer and Home Office when it comes to these individual clients. And what we see in terms of the casework that the lawyers had to do on behalf of their clients to try and assert rights tended to be seeking, first of all, to have their clients be formally identified as a victim of trafficking or modern slavery under the UK's victim identification framework, the National Referral Mechanism. They were often, alongside that, then trying to secure immigration status for their client in some way to enable some kind of continuous residence. And the mechanisms would differ depending on the individual client's experiences. Some would have concurrent claims for refugee status, so they would be lodging an asylum claim. Others would be seeking a sort of temporary stay on the basis of their status as a victim of trafficking or modern slavery. So there was a kind of multiplicity of different legal routes that the lawyers would be pursuing. An obvious point, but one which is still worth articulating, I think, is that it was really clear that more often than not, in order to try and access any form of justice for their clients, they were often trying to assert rights that on paper should accrue to their clients under domestic law or under international law. And they were being constantly frustrated by arms of the government. So in particular, it would be challenging decisions of the Home Office, either the Home Office refusing to recognise an individual as a victim of trafficking, often in spite of copious amounts of evidence, often on the Home Office's own files relating back over a number of years. They would be challenging either through judicial review or mostly through judicial review, refusals of recognition of a temporary stay in the UK, and then they would obviously be appealing refused asylum claims as well. So just to sort of mention the legal instruments that were most relevant to the lawyers, it was really the Council of Europe's Trafficking Convention, which is, unsurprising given it's a specific legal instrument designed on the basis of enhancing victim human rights in the context of trafficking. The European Convention on Human Rights was also helpful for the lawyers. And they would be often working for individual clients in the domestic setting before tribunals and courts. But then there was also what really come across in the research was the quite significant contact across the community of practice. So the lawyers had often strong networks with other lawyers carrying out similar work. They had strong connections with NGOs, and then there would often be casework that would make its way up to the European Court of Human Rights as well. I'll move on then to just say a little bit about what the research sort of pointed out about the UK government's treatment of people with lived experience of trafficking. It's been really clear over the past 5 years with increased intensity that a lot of the promise that the UK articulated around the time of the Modern Slavery Act in 2015 has really been rolling back. A lot of the protections that were promised when it comes to people who have experienced a form of exploitation deemed to be modern slavery have not been met, and this has been particularly acute in the immigration and asylum context. You really see the conflation more than ever of trafficking with immigration and asylum, and there's really been that reductive approach which has been exemplified in more recent immigration legislation in the UK. So we've had an Illegal Immigration Act, Nationality and Borders Act in recent years, all which have had the effect of allowing for protections that should accrue to those identified victims being disapplied if there's an individual deemed to have entered the UK unlawfully. And seeing as there are very few minimal lawful and safe routes by which people can make their way to the UK, this is going to be the case for the vast majority of people. And I'm a qualitative researcher, and I do love some quotes, so I'll just give you maybe one from one of the lawyers who spoke about this. So this was a solicitor who was practicing in the northwest of England. I just feel like the whole hostile environment is now everywhere. I used to think that victims of trafficking, they almost used to be treated as a slightly separate group, and the Home Office would at least place some emphasis on their vulnerability, but they're now being lumped in with everybody. All of the migrants are targeted by the Home Office. This is what it feels like to me. So there was this sort of sadness reflected across the cohort of lawyers interviewed about how a lot of the promise of the Modern Slavery Act when it comes to protection of victim survivors had not been met. I've got so many quotes, so if anybody is interested in quotes, I've got so many that I just find really pertinent. So in terms of kind of a final word and reflecting on how I see this area. Clearly now there are going to be changes in the UK context again. We have a new government, a new Labour government. We know that there will be some positive change, like we know that the Rwanda scheme, for example, will not be implemented. However, I am sceptical about the prospects for whole-scale change. There will be a new border security, asylum and immigration bill that was announced in the King's speech just this week. But I think the thing that concerns me most is that the toxicity of the debate around migration and refugees in general has reached such a kind of level of entrenchment that we are at risk of even looking at small changes in the right direction and over-exaggerating them. I think we sort of need to try and hold the line in articulating a more positive vision of migration and on asserting the particular and acute vulnerabilities of some of those individuals that have been trafficked. And I say some because I also think that we need to recognize that there is not one experience of trafficking. I think that's one of the potential dangers as well. You know, some of the lawyers would speak about how the clients that they were seeking to have identified as victims of trafficking actually felt like they'd been treated much more harmfully by the UK's Home Office than they had been by their traffickers. So I just feel like, although we may breathe a sigh of relief when a change of government comes in, or when, you know, a potential government maybe doesn't get in, but we need to be aware sometimes as well that the broader political debates may have shifted so much that we need to watch we don't lower our expectations about the standard of rights and protection that vulnerable people should be afforded. So I will leave it there. Thank you, Ronli.
Thank you so much, Samantha, for that really fascinating presentation focusing on trafficking in the UK context, and also for sharing with us some of your empirical research and also your thoughts on what may happen in the near future in the UK. Our final speaker for this panel is Associate Professor Heli Askola. Before introducing Heli, I just want to mention that there will be a short opportunity for questions at the end, so please make sure that you're thinking about those questions and jotting them down as we go. Now, Heli is going to be talking about the importance of visa status in the intersection of forced marriage, family violence, and the migration system. Heli is an Associate Professor in the Faculty of Law at Monash University and an academic member of the Castan Centre for Human Rights Law. Her research focuses on migration and citizenship, trafficking in human beings, violence against women, and international human rights. Please join me in welcoming Heli Askola.
Thanks, Ronli, and thanks for inviting me to talk about this topic. And I should say at the outset, so Ronli asked me to talk about forced marriage at the conference, and my initial response was, what's the title of the panel? And she said, it's something about modern slavery exploitation. And I said, I don't want to do it. And you know, this is largely because I guess the broader point I want to make as a sort of provocation, maybe for further talk, is that I think lumping things together under the label of modern slavery, even though we all kind of have to do it for reasons that I will also talk about, is profoundly unhelpful. And in particular, when talking about forced marriage, which is an area where I've done a little bit of work, following from my work on trafficking and then segueing into work I'm doing currently, which is really on partner migration. Lumping all of these things together, I find, is conceptually unhelpful and can result in really unhelpful responses. So I guess what I wanted to talk about then, having agreed to do this nonetheless, having said I don't want to do it, having agreed to do this, I guess what I wanted to really talk about is the gap between the sort of rhetoric of modern slavery and modern forced marriage as part of that rhetoric, and then also the reality of what we're dealing with. So between the sort of formally what we say we do, what we're addressing, and what actually happens in practice. So for instance, in the latest Australian National Action Plan on Modern Slavery, or whatever it's called, it says things like, Australia addresses the unique needs of women and children disproportionately affected by modern slavery. Australia provides holistic, gender-sensitive, culturally responsive, trauma-informed, victim-centered protection and support for all victims and survivors of modern slavery. And these are all fine sentiments and aspirations. And it's true that there's been an increased focus on modern slavery, on forced marriage as part of that, as a form of violence against women. At the same time, there are important gaps between this kind of inclusive, we're taking all things into account and our response is sensitive in every possible way, and then what happens in reality. And I want to briefly talk about two main gaps between sort of rhetoric and reality. Now, the first one is really an inadequate and only now evolving understanding and description of what forced marriage is as gender-based human rights violations go. Now, the second, I guess, gap is in relation to the inadequate response, which really flows from inadequate understanding of the phenomenon that we're dealing with. And there's a lot to be said about that, and a lot of people have said a lot about that, so I'm not going to go into great detail, and some of you may want to ask more in questions, but really, even the first issue, which is what do we mean when we talk about forced marriage, is contested. Now, it's easy in some ways for lawyers, because you can just go to the Commonwealth Criminal Code and look at Section 270 and go, hey presto, here's a definition. Yeah, there's a definition of a criminal offence, federal criminal offence, marriage without free and full consent due to some kinds of deception, threats, and coercion. Okay, so that definition exists. We only had the first successful prosecution of it. That was inserted in 2013. We had the first successful prosecution resulting in a conviction this year. Now, as Justine mentioned, the AFB statistics on who comes forward to seek support to prevent a forced marriage or help in a forced marriage, it's, I think, 411 for the last 5 years. But again, we don't know how big the numbers are, and we don't have very, very much by way of legal precedent. Now, of course, human rights lawyers can also find this quite easily in terms of definitions. Forced marriage is recognized as a human rights violation in the ICCPR, in the ICSCR. Both have the right to choose who you marry or whether indeed you marry. CEDAW has an approach based on discrimination, and of course, forced marriage entails a lot of other personal autonomy rights being violated. So that's one theoretical way of looking at it as well. But the reality of it and the empirical evidence of it is based on very limited sociological evidence in Australia. The evidence base is getting a lot better now, but for the first sort of 5-10 years, we were really fumbling in the dark. So it was a little researched, understood phenomenon, very few cases, severe consequences, but not widely understood. We now perhaps understand it a little bit better, that it's based on gendered inequalities. It's a complex form of family violence that takes place in complex familial settings, often involves young people, 16 to 18-year-olds, who face a continuum of pressures from physical force to psychological coercion. A lot of it is psychological coercion. A lot of it is associated with communities where parental or extended family involvement in marriage decisions is common. And the aims and motivations, even though these are often culturalized as a sort of cultural phenomenon, really range from transnational control of behavior to gendered ideas about family, about economics, and really practical considerations about organizing care and migration of extended family members. So there are many different circumstances that apply to any case of forced marriage, and one of the main findings from the research is that most people who are at risk or in a forced marriage don't agree with the label of forced marriage. Yeah? So that creates different kinds of obstacles to seeking assistance. The main one being that most people who are victims of forced marriage or victim survivors of forced marriage, however we want to characterize them, do not want to get their usually parents prosecuted. They seek some kind of mediation, and that's a whole different approach to forced marriage than is envisaged by the criminal law or indeed the human rights response. Anyway, there's a lot to be said about that, but that's just kind of the sociological construction of the phenomenon is still something that we don't properly understand. Now, the response then is the second problem that flows from that. So the offence of forced marriage was inserted into the Commonwealth Criminal Code in 2013 after a very short and frankly superficial consultation, which by the way suggested that you shouldn't do it. So of course they did it. So they put it under the umbrella of the various trafficking-related offences, so trafficking, slavery, servitude, etc. And now, in fact, forced marriage cases account for the majority, or the largest proportion. I think it's about 40%, but it's the largest grouping of offences that are now reported to the AFP. And because of the decision to treat it as a sort of offshoot, really what happened was we already had this scheme for trafficking. It wasn't great, but we already had it, so we thought we'll just put it there. So we put, because it's kind of exploitative and it's kind of migrant-y, we don't know why, but we'll just put it there. So we put it there, and as a response to putting it there, we now have a response to what is intimate, personal, family violence that we don't really understand, that doesn't necessarily have any migration component, which resides in not just the criminal law, but in the Commonwealth Criminal Code at the national level. So it's not even at the state and territory level where most of the family violence stuff exists and a lot of the child protection stuff exists. It's at the national level. It's run by the AFP, and I don't want to be nasty about the AFP because they've got a job to do, but they're not the ideal people to be dealing with vulnerable young people who don't want to criminalize their parents, because their job is to criminalize their parents insofar as they may have committed or may be at risk of committing this federal offence. And we've kind of stepped a little bit back away from the AFB having a central role, and there's currently a pilot where the AFB wouldn't be the entity that deals with providing support or referring people to support and providing people advice. But that's only started this year. So we've had 10 years of everyone wondering why nothing's happening in this field, because nobody wants to call the AFB, because then you're dropping in your parents. So that's the primary framework. Of course, there are other frameworks that we could use. So one's family violence, and indeed for children, various child protection things. And these exist, and they are sometimes used, but they're the afterthought, because after all, we have a designated framework, which is the one that we chose in 2013, really without thinking about it very hard. Yeah? So now we have this kind of system that doesn't work very well. Now, onto the reason why I'm in this panel, which was about migrant-y exploitation, to which I objected when Ronli first asked me. Sorry, I'm dubbing you in as a sort of, my nemesis. But it was really useful. It was actually really useful because when she suggested it to me, I said, well, I really don't want to do it because it's not a migrant thing, yeah? And treating forced marriage as a thing that migrants do to each other somewhere at the border, which may be part of it, but treating it as, presumptively that is really problematic for coming into grips with how to best respond to this kind of violence. And you can see this really clearly when you think about the migrant experience, which is that the whole response is based on the trafficking response, which presumes that the person who's been victimized or exploited has migrated. But in forced marriage, it's often not that way. Yeah, it might be that way. Yeah, so you might have migrant women who are in Australia on temporary visas, who seek to escape a forced marriage, and the current response built around the AFB is very risky for them, because calling the police says, my visa status is in fact invalid, please feel free to throw me out of the country. Yeah? And the STTP, so the current response, can sometimes work for that, and there's a little bit of sensitivity to how to deal with that. But you can then contrast that kind of situation, which appears to be the minority situation, with the vast majority, from what we know, the vast majority of forced marriage situations which involve Australian citizens and permanent residents. So they're not migrants. They are Australian citizens and permanent residents. Now, they might be of a migrant background, and hence the culturalization of the whole phenomenon, but the support needs that they have are very different, because often they are in Australia, having all of this scenario happening in Australia. There might be a migration component, but it might be quite different. Yeah? So there might be Australian citizens and residents who are taken overseas to marry someone from the extended family. And there might be Australians who then come back and are forced to sponsor the partner visa application of that person. And the kind of support that you need for that is not really the kind of thing that the AFP-led model was designed to deal with. And what we've had is basically 10 years of service organization pressure to try and shift that approach towards, taking an apple and turning it into an orange. Because we designed an apple, and now we're saying, well, the apple doesn't really work because, we don't need it. So we're trying to do this magic where we're trying to squeeze it hard enough and hope that out of the end comes a different kind of thing. Yeah? And the good news, I guess, after a 10-year sort of period of what are we doing here, the good news is that the current federal government seems to be willing to at least trial some of the things that service providers have been complaining about, namely that treating it as a migration thing isn't necessarily helpful, that having the police, the federal police, have a central role in referring people isn't helpful, even if you downgrade kind of their general involvement. And also you see a move where the states and territories, so Victoria in particular, have started to approach this from the perspective of their own system. Yeah, so the system of family violence, so it's incorporated in Victoria into the responses to family violence. It's very still incipient. It doesn't look like it's highly effective, but you now see much more complexity coming in. Now, of course, with complexity, you have a real problem, and I'll finish on that. I don't know how I'm doing on time, but with complexity, you have the real problem, which is, so here we have a federal-state relations problem. We have a problem of interagency coordination that currently exists between the AFB and DFAT and various other authorities. And by adding other actors into it, we're going to have a bigger coordination problem. But I think that's actually a price worth paying, because what we're doing currently and still trying to sort of shunt everyone through the same funnel, I don't think is very helpful. But it does raise a whole host of issues about where we go in the next 10 years, and I'm happy to talk about that in the questions. Thank you very much.
Thank you so much, Heli. Believe it or not, Heli and I actually do get along very well. And we collaborate a lot together. But thank you for that fascinating interrogation into the problems of the current framing of forced marriage in the Australian context. We are now going to open the floor for questions. I might use my prerogative as chair to ask the first question, because something that I have been thinking about as these panellists were presenting on different aspects of this really interesting subject was the fact that each presentation really focused on providing a critique of the various aspects. So Justine was talking, she was critiquing the Australian government's approach to modern slavery and the connection with corporations. And Samantha was talking about critiquing the UK approach to human trafficking, and then Heli was critiquing the framing of forced marriage in the Australian context. And I kept thinking at the end of each presentation, so what does good look like? What would a good approach be in relation to each of those kind of spaces? So I realise that that's a very big question, but I'm wondering if you can perhaps each provide a soundbite answer to that. I think there are microphones on the tables there.
Okay. This is such an interesting question, Ronli. I think for me, because I'm so often thinking around not just the law and policy on migration and its intersection with trafficking, but also the political and media rhetoric that so often surrounds so much of it. And so I think I'll sort of point to two things. An honest discussion around migration, refugee rights and trafficking that acknowledges the responsibilities of states to offer protection, not only to fulfill international obligations that we are usually all well signed up to, but also as a matter of human solidarity, and also in terms of like community building. That would be a utopia, I understand that, but making small steps towards recognizing the positive obligations and positive impact as well that a different approach could have would be helpful. And then in the kind of particular, more specific context of what I was talking about, what I don't want to imply is that I think the Modern Slavery Act 2015 was in fact the ideal scenario in and of itself, because it really wasn't. Even then, the Modern Slavery Act of 2015 in the UK didn't go very far at all in respect of extending rights and protection to identified victims. There was some positive developments, like, for example, the non-punishment principle. So the idea that those who have experienced exploitation shouldn't then be criminalized for actions that they may have taken when they were under the influence of that exploitation. That was one example of a positive development in the Act, but then even since then we've seen that it hasn't been implemented and that so often individuals are criminalized. So that's a bit of a negative answer that probably doesn't answer your question too well, but that would be my two reflections on that point. Who wants to go next?
All right. That's a really fascinating question, because if you had a clean slate, what would you do? You would not do this. But of course, we don't have a clean slate. So we've got to kind of build on what we have. I guess the major two things would be that it's odd to say this to a room full of lawyers, but we probably need fewer lawyers and certainly less criminal law, in the sense that in relation to forced marriage, the vast majority of cases that go to the AFP are cases about the risk of forced marriage. And some of them get turned down or turned away precisely because the AFP concludes that, the risk is, they can't determine the risk. And we're dealing with very different behavior because we're dealing with a potential crime, oftentimes, and we're often dealing with a quite lengthy lead-up time to the offence, which makes it difficult to treat it exclusively as a criminal justice problem. So what you really need is some kind of service-led response that is based on the risk, that doesn't follow the rules of the criminal justice system, which we've kind of built the system on now. And I'm not saying, by the way, that you should never use criminal justice. The cases of forced marriage vary tremendously, and for some, criminal justice is the right path. But what I'm saying, I guess, is that we currently have like a one-model-fits-all response, and it really doesn't. And what we need to do is really diversify both the legal response in terms of, all right, what are some civil justice prevention order kind of approaches that we could take that aren't predicated on the federal criminalization, and what's the service response? Like, what would the service response look like if it was designed, if we ignored the federal criminalization and we looked at the phenomenon, yeah? And part of the problem is that the phenomenon is relatively rare, so the numbers are small, and that's exactly why it got tacked onto the trafficking slavery thing, because that then had an automatic, there was a resource saving there by channeling those. But now, looking at the number of cases, I think you need a specialized response that isn't the response that we currently have, but that is built from the ground up, based on the evidence base that we are now growing on what actually works. So what's the support that is needed, and what would actually work? Yeah. So what is it that people in this situation look for? What kind of solutions do they look for? And how can we expand the range of alternatives, as opposed to just saying prosecutor parents, yeah, which in the vast majority of cases isn't going to work.
So I agree with what Heli's saying. I think that we've had too much focus on a criminal approach, which isn't necessarily the most effective in this field. And she's right that if you look at, if any lawyer or non-lawyer looked at the definition of modern slavery in the Modern Slavery Act, and the purpose of Australia's Modern Slavery Act is to reduce corporate abuse in supply chains and operations, and you've got forced labour and forced marriage, and everyone's like, hey, what? And that was exactly what everyone said at the start, like, it doesn't fit, there's something here that doesn't work, and of course that, now they're saying it doesn't work. So I think that the one-size-fits-all, it doesn't work, and I think the other things, what I said is that when you're designing a law, you have to think about it in the long term, and you have to think about, not only how you're defining the problem, and that you have some big sanction, but how do you incentivize change along the way? And what the law at the moment doesn't do is that crucial middle part. It's thinking about not just punishment, which it doesn't do either, but it doesn't think about incentivization. And then when you have incentivization, then you also think about companies. Some companies will, for example, willingly make changes. They'll link purpose and profits, and they'll do that. And the example I gave you from the company that's sourcing rubber from the Amazon is doing things that if I tell you, what is the big surprise they're doing? well, they're paying workers a bonus when they meet the standards that they and the workers co-designed around human rights and environmental, so that workers stay in the business, they get guaranteed income, and they're getting a sustainable source of rubber for this company because people are working in good conditions. So that doesn't seem that outrageous, to do. And so there are things that are very logical, and they're making a profit. So, but we sort of overlook this in going for the big picture sometimes. So I think we need to step back and figure out how you incentivise change, both from a government and a corporate level.